So I feel a little bit like the devil having been invited by a Southern Baptist congregation to give the sermon on Sunday morning. And the church is a little bit empty as a result. But I guess at the risk of, I think, offending sensibilities here, I want to challenge or at least play with the premise a little bit. I've been coming to conferences like this for a long time, and at every single one of them, there is an unstated or sometimes overtly stated assumption that there is this value called privacy that is being constantly eroded by the predations of government and industry and the march of technology, and that we need to sort of shore it up. And I have come to believe over the years that this vocabulary is actually a significant part of the problem, and that we are invoking a value in a way that dramatically overpromises what the policy process can deliver, will deliver, wants to deliver, or for that matter, at least in my opinion, probably should deliver. And so for the last few years, I've been playing with this question of historically, what do we understand privacy to be? And how does it interact with the things that we actually expect protection of? And so Wells and I have written this paper, which we're sort of going to loosely outline, which basically argues that we ought to think in somewhat more modest terms in terms of consumer protection. So let's start with the fact that when we talk about privacy, we're actually talking about a huge range of entirely different visions that are not actually consistent with one another, and that when we talk about privacy, we often mean highly divergent things. Some of this is just individuated, but some of it is very deeply cultural. So let me give you a few examples. In the United States, it is relatively difficult from a legal standard point of view to get a wiretap order. But once you get one based on a probable cause showing the material you collect is admissible in court. In Britain, it is quite easy to get a wiretap order, but the fruits of it are never admissible in court. Both of these completely divergent understandings of what is proper legally are defended or justified or expressed as protections of privacy. Yet they have almost nothing in common. This is the legal culture that is closest to ours in the world. Similarly, in Germany, as you all know, there is a huge sense of outrage right now at NSA practices. On the other hand, go to a hotel in Germany, and you will be asked to present your passport, the information of which will be given to the local police department. That's just a routine practice in a lot of European countries. And this is not considered a privacy invasion. If that happened in the United States, there would be riots in the street. These are expressions of what different countries understand when they use the same word, and people honestly think they're invoking the same value. And what I actually would like to suggest is that they're not, in fact, invoking the same value. They're invoking many, many different values that are culturally and also there are non-cultural features of this. There are actually a lot of different values that we conveniently sweep within the same word because we don't really want to do the work of defining what exactly we're talking about. Now, There's another factor that makes this very difficult, which is that we don't keep score well. We don't even keep score honestly, let alone well. So when we say that privacy is constantly eroding, one of the reasons we say that is that we meticulously always avoid talking about the gains that we make in privacy. It's as though we categorize only the things that hurt us in this field. So we have this perception of constant erosion. Let me give you an example of that. If you were, there's a wonderful scene in the Woody Allen movie Bananas, where Woody Allen, so late 1960s, I suppose, goes to the newsstand to buy pornography. And it's a comic scene where he's trying to hide the porn that he's buying underneath National Review and The Nation and all these other magazines, and his humiliation when the person who's checking him out calls him out on it. To anybody who's male above a certain age, remembering being 13 and buying, Playboy or whatever is one of those searing memories of having to look somebody in the face and tell them, I want that, right? And that is a privacy that, 13-year-olds today have that I venture to guess that most of us did not have. And that's a frivolous example, but it's a frivolous example of a non-frivolous point. If you're a pregnant teenager, you have the ability to get information today. Yes, it is ultimately trackable. But no, it is most unlikely to be tracked in a fashion to your detriment. It is very likely that you have access to information in the privacy of your own home that you used to have to go and talk to somebody and look somebody in the face about. There are a lot of examples like that. Think about, I've often thought that people should do a study of the effect on condom use of the installation in CVS of automatic checkout machines so that people actually don't have to look somebody in the eye and talk about their sex life, even at the level of, that'll be $3.80. We don't count these as privacy gains because we actually don't count privacy gains. And if you keep the score well, it is not at all clear, at least not at all clear to me, that the net effect of privacy of the combination of policy, consumer options that we have, big data, and policy is negative. It's not clear to me that it's positive, by the way. It's just not clear to me that we've ever really evaluated it carefully. So if we don't count the areas of privacy gain and we don't have a common understanding of what the value is, the question becomes whether there is some common core of things, promises, that constitute privacy however anybody defines them. That is there any list of obligations that no matter where you fall on that spectrum, we can say brings together government, enforcement actions, the major companies, a sort of common core of privacy elements. So here's the thing is, I think there actually is. And the interesting thing is that there's no English language word that defines that set, that identifies that set of values. You can actually go through and find them. But there's no word in English to describe what that is. So in this paper, Wells and I have sort of adventurously tried to supply the English language with such a word, which we dubbed Databuse. And so let's just tick through what the elements of it are. So I think these are elements, now just for the sake of having a remotely contained project, we tried to limit the discussion, or we limited the discussion only to first-party relationships with companies that are providing a service in exchange for your data. So we sort of specifically set aside the government set of issues, and we specifically set aside the data brokers issue where there is no first party, direct relationship with the subject of the data. And so the question is, can you identify is there something in common that, will bring together, the FIPS elements, what the White House promises in the Consumer Privacy Bill of Rights, that unifies the FTC enforcement action somehow, and that the corporations that do this data processing and collection actually promise to observe. So I think the answer is yes, there is, and it looks something like the following. One is the secure storage of data. Nobody seriously defends the proposition that companies should sort of take your data and then leak it, or not keep good, secure practice of it. Nobody really defends that. I think everybody also agrees that companies that take your data should not actively use it in a fashion prejudicial to your interests. Now, that's a complicated one because your interests people have very different perceptions of what their interests are. People have very different perceptions of what prejudicial to those interests are, and how private a person you are will guide, but there's some outer boundary. Similarly, there's in all of these elements, in all of these components, there's an understanding that there is a need for transparency and honest accounting of what is and isn't being done. You sort of have a right to know what you're giving up when you turn over data to these companies. And then finally, and I think this one's more emergent than inherent, but there is a promise of user control. And that, if you look at, sort of both Facebook and Google have really moved decisively in this direction, but there's a fair bit of granular control about who gets what. And I think that's partly a reaction to consumer demand. And it's partly a reaction to the fact that nobody feels quite comfortable saying out loud, once you give us X, you lose all control over it and your sort of fate is in our hands, so there. And I think what this amounts to, if you think about, these set of things will account for essentially all FTC enforcement actions. I've never found one. Wells will talk a little bit about the details of that, but we weren't able to really find one example where the FTC was enforcing outside the boundaries of those basic obligations. And what it amounts to is some kind of a promise of trusteeship. If you look at the obligations to a trustee in the financial sense, there's a certain parallel between what the trustee is obliged to do vis-a-vis the subject of the trust, to operate in his interests, not to do certain things. It's a very close relationship between aspects of what we expect of companies to which we fork over data and what we expect of trustees. There's differences too, but it's not a bad way of thinking about the basic relationship. This vision is very modest. And I understand that to a privacy-oriented audience, it sounds ludicrously modest, right? That it's not asking for protection for, sort of subjective harms, right? Where having data out there about us makes us feel. It's not asking for protection from, it's not asking for a right to be forgotten. It's not asking for, a protection against targeted advertising that we may find annoying, but that we tolerate because we enjoy the services companies give us. And it's not asking for any assumptions about what direction the market will move in terms of how people feel about the relative value of sharing data versus not sharing data. It's really asking only that we have a clear understanding of what is and isn't going to be done, what the costs are and aren't of, of engaging companies on this basis. Another way to think about it, and then I'll turn it over to Wells, is that there's sort of a three-part hierarchy here of a three-tiered hierarchy of interests. The part that no one regards as controversial, and I think nobody from the most fervent privacy advocate does not have a problem with, right, is areas where use of your data by a company serves both your interest and the company's interest. The user interest and the company's interests are congruent. A lot of privacy visions, however, also would regulate or prohibit or express anxiety about situations in which the use of your data does you no particular immediate harm, but advantages the company. These are situations in which you may not like that your data is out there in some sense, that your data is being manipulated for somebody else's benefit, but you also can't put your finger on what the tangible harm is to you, either in the short term or the long term. I think a good way to think about the difference between a Databuse vision of consumer protection and a broader privacy vision of consumer protection is whether you do or do not seek to regulate activity within this second category. Finally, the third area is an area where I think in any vision you're going to want to regulate, which is an area where the use of the data is in the company's interest and adverse to your interest in some discernible sense. I think the Databuse vision focuses almost entirely on that third category. It leaves category 2 unregulated and sort of subject to consumer-company relations. Nobody really fights about the first tier. So Wells will lay out a sort of more granular sense of the relationship between rhetoric and enforcement, and how we often talk in terms of very broad visions of privacy, but we actually act, and in the FTC's history, almost uniformly acts in this third category that's very clearly Databuse.
Thank you, Ben, and just wanted to reiterate, we feel enormous gratitude at having the opportunity to participate in CFP. We're big CFP fans, so thank you. I'm just going to speak very briefly about some of the particulars of our paper in terms of the government's, how the government's activities, both the things that it does do and proposes to sort of fit in. I was very interested to hear on the prior panel about data brokers, about informal briefings with the government. Sometimes I've had my own small part in these discussions, and you do hear some people say my hands are tied. You can hear that from the government in a variety of contexts. But so far as first parties are concerned, I actually think the government, at least with respect to the consensus principles we've identified, its hands are not very tied. As Ben mentioned, no one really desires enforcement or significant legislative change in a first category where consumer interests and business interests are essentially aligned. Category 2 is something that, so far as we've ascertained, the government does not take action against, and in point of fact, usually does not seek the authority to take action against. And all that having been said, there's a third category where you have some tension between, and that's where all the FTC, that's essentially where the FTC concentrates its work, and mostly where legislative proposals are talking about broadening authority to act. So I don't think there's a hands-tying problem there. I mean, I realize there are issues in the first part, there are reasons why the first-party relationship might be a little easier, so to speak, than the data broker relationship. But just ticking through the consensus principles and what we've seen from the government, deception, again, there's really no argument there. And when Google said we're not going to share user data outside the four corners of our email service and did it anyway in beta testing, a social media program, the FTC acted. Ditto MySpace, when MySpace represented its compliance with the safe harbor and that it would not share data outside the four corners of its privacy policy, the FTC acted there. And you can sort of list out, you know, and I think the deception category is one, since it's so long-standing and goes back to the FTC Act's plain language, this is one where you're just going to see lots and lots and lots of activity, and that's to the good. Another area which is, I think, maybe a little bit more legally controversial, but we think is sort of a policy matter, which is bordering unsettled, which is at some nature of data security. I mean, data security is another area where, by and large, if you talk to people in this space, depending upon how granular you want to make the discussion, your odds are pretty good you're going to chorus as one saying that we're going to need some kind of data security statute or some kind of data security protection, something in that space that we don't have already that's cross-cutting. But in the meantime, actually, using its FTC Act authority, the Commission has said, well, we're going to move into this space too. Let me just, you know, the obvious example here is Wyndham Hotels, where it's being litigated, where the Commission just won a significant victory. There may be some legal controversy over the reach of the statute, and the corporate world is, I think, pushing that point, back against that very significantly. But in our view, that's a pretty healthy thing for the Commission to be doing, and reflects, again, a measure of agreement broadly that data has to be kept reasonably safe. And if you look at the facts of the case too, what the Commission alleged there, you know, you're not talking necessarily about you screwed that thing up, or this one system was unsafe, or you're talking about the repeated ignorance of major security problems over time, something that you would want a government enforcement agency to be in the business of doing. And finally, there's certain kinds of data where for a long time, maybe not so much through the FTC Act, but through COPA or things like that, where activities in the home or sensitive activities involving kids, for example, again, that's been a really, really big area of activity for the Commission and the government more broadly. The PATH case, the Designerware and Aaron's cases, some ones that got the corporate world wrangles up a little bit. But again, when you're talking about being able to see people in their houses doing things or using false pretenses to get information from people under the age of 13 without their parents' consent, that is another area where you've seen a lot of enforcement activity. And again, that's something that we think both reflects consensus and it's a good thing, and there should be a lot more of. That's sort of point one. Point two is that in identifying all these principles, for the most part, when the government talks about what it's doing, this goes to the hands are tied point. I think a corollary to when you say privately off the record, my hands are tied, there's maybe a little bit of hydraulic pressure at the other end to say, you know what, publicly anyway, to say, actually my hands aren't tied, and we're going to give you something in terms of protection that's pretty generous. If you go to the off-the-record briefing, you say this is a really bad thing, and you get an explanation that involves the political process and the multi-stakeholders that you're going to have to deal with. Publicly, the rhetoric can be a little grander. Our government is usually pretty conservative in that regard, with some notable examples. But you know, I mean, you can use it. To use an easy example, is the right to be forgotten. Obviously, that's you know, plenty of talk at this conference about that. But you know, if you look at legal filings, for example, no one thinks the right to be forgotten is actually an unqualified legal right. I mean, if you look at it, even people who are staunch advocates of it will tell you that it applies in certain contexts, but not others. And even with a significant court ruling about what it consists of, they're going to have to sort of work out its parameters through litigation for a long time. But that having been said, the European vision of that is significantly broader than what you would get in this space. But even the Commission from time to time, as we have noted, has used rhetoric that goes beyond some of these principles that we've identified. Not so much with respect to the data broker report, which came out very recently, which again is not the subject of this paper, but in the first party setting, the preliminary staff report, which came out a few years ago, talked about defining the boundaries of not the boundaries, but defining what privacy harms really are. Fears of being monitored, the subjective fears about having lots and lots of data out there. Things that everybody, I think, would probably acknowledge are real, but that despite having talked about it in that way, the government doesn't actually seek to punish and isn't asking Congress or the executive branch, for that matter, for authority to punish. And then similar language along those lines in the Commission's final report, which came out shortly thereafter, which didn't exactly use the same language, but used language to suggest, again, that you might encompass broader things than the traditional harms that it had fit into the FTC Act over time. So that's sort of a separate point. Point one is that the government is usually behaving in a way that's consistent with our theory, or it's asking for the power to do so. But point two is that from time to time, that it can talk about its privacy enforcement work in a way that actually goes beyond that, and that's not good. I don't want to overstate the case here that make it sound like the government is, that the FTC or that anyone is going around the world saying we're going to do something radically at variance from what actually happens. So that's not our claim. But that from time to time, the privacy rhetoric can indeed overpromise, at least when you look at it in this fashion and see what things are the subject of enforcement and what sorts of things the government wants to make the subject of enforcement. But I think
So we've babbled. So we've babbled. We have babbled long enough. If people have thoughts, challenges, questions, we'd be happy to engage. Sure.
Sir.
It strikes me there's two aspects of what you're saying. One is the descriptive aspect.
Let me interrupt you and congratulate you for just addressing me directly without going to the microphone. No, I'm being serious. Well, maybe so. Is it being recorded? Ah.
For perpetuity. It strikes me there's two aspects of what you're saying. One is the descriptive, that this characterizes the FTC actions and where to date there is consensus amongst the different perspectives. And two is, it seems you're going farther. You're saying the normative one, that, well, this is the right foundation for thinking going forward, rather as opposed to saying, well, this is the current consensus and there's a case to be strengthening it to cover the areas of privacy, sentiment, et cetera. And so I'd wonder if you'd like to talk about the normative side.
I'll just say one word about that. And, our view is not that there is a normative component to what we're saying, no doubt, but we are not saying that the current setup is optimal and that we would brook no legislative change. Or for that matter, it's sort of, there's a philosophical problem in saying that we've established consensus principles and that's all that there can be never any change. Obviously there's room to change things as needed there.
So I would just say that this is actually an area in which I think the authors probably don't entirely agree. And Wells is probably a lot closer to where some of you are than I am. So just to be provocative, I'll lay out the hardest version of the thesis, which actually isn't in the paper, but is what I actually believe. The hardest version of the thesis is that, at least as regards the first-party relationship, we have largely achieved the right answer at this point, and that there's a reason why these principles are actually recurring in virtually every document that everybody puts forward, and that it's that they get to something like the social contract of sharing your data for free with a company in exchange for a service. And that's that you want a certain fair dealing in that, and you accept that the company is going to exploit that for purposes of your own. What you're really asking for is that those purposes not conflict directly with your own purposes, and that you have the opportunity to make that assessment yourself. Now, Wells is less hard line about that than I am, and so the paper itself may be a little bit gentler than I feel about it, but that's actually my view, and I think the normative component, the descriptive component, reflects a normative comfort level that and incidentally, that I do not have about the third-party relationship, where I think we're sort of at the beginning of a conversation that's profoundly different and very difficult, because it implicates both no consumer choice in having gotten involved in the relationship in the first place, no consumer control, and also implicates, on the other hand, and pushing in the other direction, First Amendment values in a very profound way. And so I actually think in the context of the third-party relationship, the stakes are way accentuated in both directions. But in the context of the first-party relationship, I actually think we're kind of pretty close to we're pretty close to something like the right answer. And I think that's sort of one of these things that the political community hasn't quite noticed, that, you know, we have kind of groped our way to, through a combination of enforcement actions, companies just kind of responding to consumer needs, threats of legislation that often haven't actually resulted in legislation, but kind of threats of legislation that seem to get incorporated in case law, particularly on the, you know, on the data security side. We talk about the need for a data statute, which I certainly wouldn't, a data security statute, which I certainly wouldn't oppose. And it turns out Wyndham Hotel says you don't really need it, you have it anyway, you know. And so I think it has actually been a sort of migration to something like what the Spiritus Mundi actually thinks Facebook really owes you as a consumer. Please.
Hi, my name's Adam Thier. I'm with the Mercatus Center at George Mason University. I really enjoyed this paper. It was really thoughtful and excellent.
Thank you.
I want to ask you two questions. The first is, when you're talking about the principles that motivate your approach here, you get to the fifth of saying companies have an obligation to honor the commitments they made to consumers regarding the handling of their data. I've spent some time myself writing about that sort of an approach and talking about holding companies to the promises they make to their own consumers. The pushback I get on that point, and I'm interested in your answer to this, is, well, what about the companies outside of the bigger names, the Googles, the Facebooks, the Apples of the world, who make explicit promises? They have clear privacy policies and other commitments they make and other public statements and documents. What about the smaller companies, the fly-by-night operators, the new entrants, the folks who maybe aren't as well established, who haven't even made any commitments? They don't really say anything. I mean, is there a requirement that they have to make those commitments, make them more public, more transparent? If so, how? Why don't you answer that, and I'll ask a second.
Just before Ben jumps in, I would say just one thing. I've heard something similar, and I think that the shelf life of a company that can actually affirmatively sort of live without making an affirmative representation of some kind is pretty limited. I don't mean the problem goes away. I don't have a great answer for that, because a regulatory regime in this space has costs, and I'm not sure I love those costs, but the time between when you start handling data, I mean, the privacy report talks about this with the White House, right? I mean, it doesn't cover everybody, but if you want to play in this space for a long time, such that you're big enough that, you know, a nonprofit knows who you are, you have someone in this kind of discussion, odds are pretty good you're going to be taking in enough information pretty quickly to make it impossible for you not to say something, not to take a view. But I mean, I don't know I don't know candidly the best answer about what optimally the balance of cost, the sort of barriers to entry for innovators. It's a concern, and I think it's real.
So I would just add to that to me the relevant question is not how big the company is, but what the magnitude and of the collection is.
Right,
and
right.
you know, if you're a very small company and you're collecting a lot of personal data on individuals, and you're not making representations about what you are and are not doing with that information, shame on you. And if somebody feels like they are misled, I imagine you would and should be subject to litigation about that. And the fact that you haven't made representations actually could make matters a lot worse for you. So to me, the relevant question, now I understand that making those representations is itself a complicated endeavor that, you know, a company like Google is better positioned to do than a company that just started up. But look, I think that's what goes to the question of trusteeship. You're taking a lot of data from people, a lot of interesting, you know, revealing information about data. You do have an obligation to say what you will and won't do with it. And I think if Congress wanted to strengthen, you know, the basic foundations, it seems to me, you know, figuring out at what point you do have an obligation to kind of go on the record and make those representations would be a very kind of healthy way to sort of strengthen the foundations of a Databuse, you know, vision of privacy. Sorry, you had another. Okay.
So what can we do when the contract between the company and the user is in the form of an EOLA, which is highly cryptic, and then the company does whatever it wants?
Go ahead.
Well, I mean, if you want to say like you're standing here in this room, what your legal options are, I mean, I can understand if you've got a, you know, an agreement that's Byzantine or is kind of left, maybe if you're talking about a contract is like one of the worst examples of, you know, what the privacy community thinks are like the worst examples of notice and choice or something like that. Our vision is that you wouldn't have that. You would have a better account and a sort of exceedingly lawyered up version of what the company's going to do that indirectly suggests one use but actually really means another, or is so dense as to defy meaning. I mean, that's something that we think is inconsistent with this model. So
My example is, for example, in mobile applications. You get an EOLA, you read it, you accept some conditions to use the application. But it's very hard to understand exactly what is the application tracking, when it's tracking. It's very hard even for a software engineer to understand exactly what an application is going to do. I want to install an application and I want to know what it's going to do. It's very, very, very hard.
Right, and so, I mean, I think, again, this is, you know, an area where legislative or regulatory requirements for greater clarity and greater simplicity make a lot of sense, and again, would be a part of, if you imagine this as the core, and the goal of privacy policy, rather than expanding the core, would be strengthening the core. This would be an area you could really imagine good policymaking actually playing a very constructive role in, saying, okay, we're not going to tell you what it has to be, but here are the questions you need to answer. Here's the advice you need to give consumers, and maybe here's the, you know, here's the size, right, of the, you know, the font can't be, you know, so small and so, right, 30 pages of impenetrable text. I haven't thought through what the detail of a set of disclosures are, but there are a lot of areas, think of food labeling, right, where the FDA says, you know, here's the nutrition information that needs to be on, like, everything you buy that you eat. And a lot of legislative work and regulatory work goes into thinking about what the natures of those disclosures should and shouldn't be. I think if you imagine that one of the core foundations of a real, of the core kind of foundational ideas of the first party relationship is you got to know what you're getting into. I believe that's part of the basic relationship. You should know in any contractual relationship, you should know what you're getting into. We have truth in lending rules that protect your knowledge in that context, right? We have, you know, there's all kinds of areas where we recognize your right to make the contract, but we require that you know what you're getting into, that you have a certain level of disclosure. And I could really see that as part of the answer to your question.
I know that companies will always come back and say, well, thank you for that recommendation that would be simple and straightforward, but we deal in a very, very, very complicated technical environment. And the reason why there's a lot of technica and a lot of twists and turns in our disclosures is because the technica is very frickin' technical, right? And I think that's true to a point. And what gives me hope in this area actually is something of an analogy. I think it's an article of faith in the privacy world and the surveillance world that the current surveillance regime is maddeningly complicated, and that not merely because a lot of government surveillance activities are secret, but also because the rules themselves in the pursuit of a more transparent, more effectively regulated regime, you have this dense code of stuff that only real experts in the privacy world or the surveillance world can truly decipher. The thing that gives me a little hope in this regard is, you know, a couple years ago, a guy within government who is almost universally acknowledged to be at least before Snowden. After Snowden, everyone's an expert in FISA, right? People on CNN just randomly show up and say like, "Yeah, I'm FISA expert," right? Before all that happened, this fellow was universally regarded as one of the top 5 people who could really sort of give you a walkthrough on the government surveillance programs and the rules that regulated them in all of their exquisite complexity. He had envisioned a much simpler process that could accommodate the government's need to actually know the programs it's operating and the rules under which they're going to operate for the same good of the privacy people and the people being surveilled, that they could actually have a better sense. And to do that with some much more crisply written, much simpler, much more crisply written, and much more comprehensible. Would it remove complexity entirely? No. But if that guy can get that confident about doing that, making that sort of innovation, when you're talking about collection of all telephony metadata in the United States, I think we could probably make some progress in that regard with representations to consumers in the first party setting.
Thank you.
My name is Irakli. I wanted to follow up on the question about the ULA and ask another question. Sometimes legislature is not the answer, and I would argue that the reason
Sorry, I didn't hear you. Sometimes legislatures.
is not the answer to the problem.
Sorry.
And I could argue that part of the reason why those contracts are so complicated and so long is because there are a lot of laws that these companies are afraid of. And specifically to the aspect of protecting the consumer, actually without any legislation in the ecosystem like iOS ecosystem or Android ecosystem, now if I install the application, it actually asks me for key things like this application is trying to track your location, is trying to transmit certain data. Do you agree to that?
Right.
And this was done not by the government, but by Google and Apple themselves, just trying to provide a better user experience to their users. And I think that there are a lot of cases, and this relates to what you were saying in your work, that sometimes we talk about privacy, but the real issue is not the privacy, but some of the fears and some of the other experiences that we're just wrapping into the overall umbrella of the privacy. And here's the question. Do you think it's a good idea that for some of those problems, maybe what we do is we advocate to the large corporations, the ones that actually have the power to make the change, to Google and Apple, and don't go always through the government and don't try to always punish some bad behavior, but maybe just incentivize good behavior outside of the government regulation?
So a few things. One is, I agree with you completely that relatively rarely is highly specific legislation the right answer. When we legislate, we tend to legislate on the basis of technology that exists right now, and it becomes obsolete very, very quickly. One of the virtues of the FTC Act is that it's really old and really general. It forbids unfair trade practices, right? It forbids consumer deception, these sort of very high-level principles that then through a kind of common law process of suing companies and companies settling and companies occasionally winning and the FTC winning, you get application to more specific technologies. And there's something to be said for non-sector specific, high-altitude principle laws that basically say, don't do anything too bad, right? And then you apply those to different sort of technological arenas at different times. I also agree with you that most of the time it doesn't and shouldn't come to that. And if you look at the development of privacy interfaces on Google and Facebook, you get a really good example of that, that these companies were, and the case in Facebook is more dramatic because they went from, being the real bad child in the eyes of a lot of people. They have a lot of granular control over who can see what on their interface now, and their interface is still a little hard to find, which is kind of interesting. But there's a lot of user control at this point, and that is a response to exactly what you're describing, which is their users being upset with them about what control they didn't have. And I think it was also a sense of the probability of regulatory enforcement. It was also probably a lot of other things, but the core instrument is consumer demand and a sense that, and if you look at the pattern over time, at least with respect to the big companies, and I take your point that the little companies can be outliers in all kinds of directions, but at least with respect to the big companies, over time, there is a migration, very pronounced, very clear, toward not just observance of these basic principles, but to very public embrace of them and to sort of putting themselves forwards as good citizens in this. And I think that reflects actually both a sense of what the legislature would tolerate, a sense of what the consumers demand, a sense of what enforcers would enforce against, and a sense of what courts would do. And that's, I think, because this is a kind of spiritus mundi sort of vision of what the consumer is entitled to in these first-party relationships that's kind of gone tectonic on us. But yes, I think very rarely is the answer going to be Congress should pass a law mandating blank.
Just a tiny point, actually, I think responsive to both of your points, is that there, and again, this goes to we tend to use privacy talk for this entire thing, and the essence of our paper is to say, well, maybe we ought to be more focused on consumer protection, at least in this relationship. The FTC also has more than one jurisdiction too, and it informs the way they think about it, which is another sort of salutary thing about the status quo, which is that it thinks about, in antitrust terms, about privacy from time to time. It starts, I think this is another thing you can kind of see where they've been judicious about, but informs their FTC Act enforcement, is that they are aware, and you can see this in some public remarks by the commissioners over the years, they are aware that they're not trying to create a regime where privacy compliance creates a monopoly. And that's something they're sensitive to.
Thank you.
So I think we have time for one more question.
So my follow-up was going to be about how well your model and your trusteeship notion in general scales up to the next set of challenges, privacy-related challenges associated with the Internet of Things, wearable technologies, and the sort of world of even more decentralized technological innovation that we see forthcoming.
Ask us 10 years from now.
Well, the problem is, of course, that this stuff's here now.
Of course.
Right, and the policymakers are thinking about it. But what you say in your report, when you're talking about the trusteeship model, is that it gloms on well to the traditional FIPS principles and to some of the things that the Obama administration's been saying in its privacy reports, and that you're building on that. But that model begins with the notion of notice and consent as being sort of primary among these FIPS principles. And only recently, in the White House Big Data report, has there been more of a discussion about maybe a move away from that to sort of use-based restrictions, precisely because of the limitations of FIPS in a world of Internet of Things and wearable technologies. So talk to us about trusteeship and your model in a world like that, and how you envision enforcement working when maybe there aren't even some of the choke points of large corporations to go after in that.
Right. So here's the key. The trustee. This is the reason that trusteeship is actually a valuable way to think about this. If you think about traditional trusteeship, and as I said before, there are differences here, right? The trustee is obliged to act only in the interests of the subject of the trust, right? Not ever for his own goods. We don't ask that of Google. We understand that Google's going to make money off of our data, that that's its business model, and we're all perfectly savvy to that. But we do ask that that may involve our exploitation, but it does not come at our expense, at least not in ways that we don't have some ability to veto, say no to, control. Now, this seems to me to translate really well to the Internet of Things. I don't know to what degree 5 years from now I'm going to be wearing technology that asks me to be a cyborg, that turns me into a cyborg, and that, Fitbit or whatever company you want just gets massive amounts of biometric data about what I'm doing on a minute-to-minute basis. But here's what I do know. Whatever that company is doing, whatever they're collecting, I don't want them to use it in a way that's hostile to my interests. And I want to be able to have some sense of what they're going to be doing, some sense of the nature of the exploitation, and the ability, I don't like the phrase notice and consent, because that implies that I'm getting a detailed statement, and it almost implies exactly the sort of contract detail that in fact is counterproductive. But I do want a reasonable accounting of what the costs to me are going to be of engaging this system. And that's true whether it's Google today or whether it's, the company that's going to make a watch that does, things I can't imagine. And I think that expectation that who's ever collecting massive amounts of data about me in exchange for some service that they're providing me has a trusteeship obligation to me is the core. And notice that I can say that without any reference to the concept of privacy. That basic sense of a kind of bilateral obligationship of trust is, I think, the core of what we should be trying to protect in the first-party context. Thank you very much.
Appreciate it.